Okay, fantastic. Welcome everyone to the Centre for Environmental Law and Nature Dialogue Seminar Series. And today we have the amazing Professor Karen Scott speaking to us on the topic of the BBNJ agreement and the question of will the BBNJ agreement support efforts to mitigate the impacts of climate change on high seas biodiversity. Brief introduction to Karen. Professor Scott is a Professor of Law at the University of Canterbury in New Zealand. She teaches and researches in the area of law of the sea, international environmental law, and Antarctic law and policy. Recent research projects have focused on ocean acidification and due diligence obligations, marine protected areas in the Southern Ocean, and informal lawmaking and area-based protection. Recent books edited by Karen include the Routledge Handbook of International Environmental Law, the Research Handbook on Polar Law, and Changing Actors in International Law. Karen is the Editor-in-Chief of Ocean Development and International Law and the current President of the Australia and New Zealand Society of International Law. We're absolutely delighted to have you here with us today, Karen. I will pass over to you, and then we're hoping that after your presentation, we'll have a kind of open forum for questions, both in the chat, and if anyone wants to raise their hands, I'll try and kind of manage those questions as we go. But for now, take it away. So happy to have you.
Well, kia ora, Hannah. Thank you very much. I'm really delighted to be part of this seminar series. I'm very grateful for the invitation to participate, and I think I shall insist in future that I should always be introduced as the amazing Karen Scott, because I quite like that affiliation. So I'm just going to see if I can share my screen and get my slides running. It did work earlier. Yep, that seems to have worked. So I'll just go there. Right, can everybody see that? Oh, now I know somebody had an issue with this yesterday. I've never, I'm wondering whether that is because I actually have two screens and it's now slightly confusing me. Okay, but I think I might just let it go because I actually don't know how to fix that. So hopefully that is okay for everyone. So Hannah very kindly invited me to talk about the BBNJ agreement, the agreement which is currently under negotiation under the auspices of the United Nations Convention on the Law of the Sea, and is designed to address the conservation and sustainable use of biodiversity beyond national jurisdiction. It's actually one of the most exciting, I think, kind of current developments in the law of the sea and biodiversity fields. It'll be sort of the first sort of major global multilateral agreement in quite some years. What I'd like to do this afternoon is to look at this agreement really through the lens of climate change and really ask whether this agreement has some potential to really address the impacts of climate change and indeed ocean acidification on the high sea. So that's really going to be my question today, rather than looking at the agreement more generally, but I'm really happy to talk about other aspects of the agreement if there's interest in the discussion. So I suspect for this audience, I don't need to say too much about the impact of climate change on the ocean. I imagine you are all experts in this field, the sort of triple threat, as it's often described, being increased ocean temperature, increased ocean acidity, and deoxygenation, really as a consequence of an excess of carbon dioxide being drawn down into the oceans, and of course the oceans also absorbing heat. The impacts of climate change and indeed ocean acidification include things like sea level rise, coral bleaching, toxic algae events, latitudinal abundance shifts in marine species, including fisheries, so essentially fisheries moving north or to different latitudes as a consequence of temperature rise, reduced biodiversity and decline in fish stocks as a consequence of lower oxygen levels, an increased number of extreme weather events. I think it's probably fair to say that we know more about the potential impacts of climate change on coastal ecosystems in contrast to deep sea ecosystems, but there doesn't seem to be any doubt that climate change and ocean acidification will impact deep sea ecosystems, and those impacts may well be quite significant. The second World Ocean Assessment, which was released just last week, highlighted the increase in the number of heat waves and noted that those heat waves can penetrate multiple hundreds of meters into the deep ocean and affect ocean basins. They've estimated that these heat waves have actually doubled in frequency between 1982 and 2016, and those, of course, in this region will be aware of the quite major heat wave over the last couple of years off the west coast of New Zealand. It's predicted that rising ocean temperatures may lead to enhanced stratification, nutrient limitation, and shifts towards small phytoplankton, and this will impact pelagic or high seas species. The report also highlights the potential impact of ocean acidification, including changes in gene expression, physiology, reproduction, and behaviour. And the report also particularly notes the potential impact on deep water corals. The legal issue, or one of the legal issues that we have had until recently, although I think is still the case, although it has improved somewhat, is that we don't in fact have an overarching sort of regime which addresses the impact of climate change on the oceans. And in fact, the sort of regime we do have has been described, or at least I've described it, as a regime complex. So we have disparate regimes which do address climate change and indeed to a lesser extent ocean acidification, and these are functionally overlapping parallel regimes which are non-hierarchical but which nevertheless affect one another's sphere of influence. So that's the basic definition of a regime complex. And I've just put very broadly on the slides there sort of the three: climate change, regime, law of the sea, and biodiversity law, which is not to exclude other areas of law which also impact this area. So the primary obligations with respect to climate change, and in particular to mitigate CO2 and other greenhouse gas emissions, of course, are provided for under the climate change regime. So that's the 1992 United Nations Convention Framework on Climate Change, and of course the Kyoto Protocol and Paris Agreement. But the climate change regime is primarily focused really on the atmosphere and the terrestrial environment. It has until very recently paid very little attention to the oceans. And just a really crude example, the overarching goal to keep temperatures at a maximum of 2 degrees, preferably 1.5, have not really been assessed in terms of their appropriateness for the oceans. And research would actually suggest quite significant impacts at actually quite low levels of temperature rise. And of course, that is a temperature target. It is not an ocean pH target, and that is not something which has been provided for. If we take the law of the sea, there's clearly a mandate, as any of you that are working in this area would know. There are broad obligations relating to pollution. There's a specific reference to atmospheric pollution, so there's no problem in principle in the law of the sea in addressing climate change, but it hasn't really done so outside of the area of shipping through the IMO. It has largely left the matter to the climate change regime. So basically, this is an issue which has kind of fallen between the regimes, if you like. Now, in order to try to address this gap or sort of bridge the two regimes, other instruments have come into play, and that I think is where actually biodiversity law has played quite an important role. So the Biodiversity Convention in particular has played quite an important role in attempting to get climate change and ocean sort of up the agenda of both institutions, and indeed on the agenda of other institutions such as fisheries and regional seas organisations. Soft law is another way of trying to bridge those various regimes. So SDG 14, particularly in relation to 14.3 ocean acidification, for example, would be one example. And I think at the regional level, it's fair to say there's been real attempts to try to address climate change through certain regional seas instruments and through, to a lesser extent, regional fisheries management organisations. Over the last couple of years, I think it's really important to acknowledge that the climate change regime actually has thought a bit more about oceans, and there have been a number of initiatives which have come through the climate regime itself in relation to oceans. So the primary mechanism to require states to meet these targets, of course, is through nationally determined contributions under the Paris Agreement. And about 70% of those NDCs actually contain targets or objectives associated with oceans, primarily in relation to adaptation, but not solely in relation to adaptation. The ocean has been designated as one of 9 global action events that took place in 2016. The Global Ocean Acidification Observing Network was also established that same year by the UNFCCC. And the Strategic Action Roadmap on Oceans and Climate, 2016 to 2021, so due to terminate this year, which sets out 6 policy recommendations relating to the role of the oceans in the climate. Mitigation, adaptation, displacement, financing, and capacity development was also adopted that same year. Next year, 2017, the Oceans Pathway was launched, endorsing a 2-track strategy to increase the consideration of oceans within the UNFCCC. And in 2019, COP25 was sort of described as the blue COP. I think perhaps a bit of an overstatement, but trying to acknowledge the sort of increased focus on the oceans, and indeed the COP requested a dialogue on oceans and climate change in order to strengthen both mitigation and adaptation. And of course, it'll be interesting to see what happens at COP26, assuming that is able to go ahead in Glasgow this year. But what I want to do, rather than looking at sort of the oceans climate nexus more generally, is to focus a bit more specifically on the potential for this new instrument, which is currently under negotiation, and see really, can the BBNJ agreement operate as a bit of a bridge between the regimes, and will it serve to actually integrate climate change into oceans decision making to a much more effective degree. So just a bit of background in relation to this instrument. The formal title is the International Legally Binding Instrument under the United Nations Convention on the Law of the Sea on the Conservation and Sustainable Use of Marine Biological Diversity in Areas Beyond National Jurisdiction. Law of the Sea instruments are not necessarily known for their pithy titles, and I think this is an example of that. Often it's referred to as the IBLI, which I find quite hard to say, so I will refer to it as the BBNJ agreement, so the Biodiversity Beyond National Jurisdiction agreement. The question of whether we should have mechanisms, principles, and processes for conserving biodiversity beyond national jurisdiction was under consideration by the United Nations General Assembly since 2004. So this has been quite a long process in terms of getting to where we are now. In 2015, the UN General Assembly took the decision to establish a formal preparatory committee for the purpose of developing a binding instrument under the Law of the Sea Convention. And the Law of the Sea Convention, of course, is the global treaty which applies or which regulates really all activities taking place on the oceans, often described as the Constitution for the Oceans. Formal negotiations were instituted in 2017. First round of negotiations took place in 2018, but of course, like many or most international processes, there has been something of a hiatus as a consequence of COVID. It is hoped that the 4th session, which technically should be the final, but if you have a look at the draft text, I think it's hard to think it might be the final. That has now been scheduled for August this year. And again, it'll be interesting to see whether that actually does go ahead. So the agreement will cover 4 broad areas relating to the conservation and sustainable use of biodiversity in beyond national jurisdiction. And these include marine genetic resources, including questions relating to the sharing of their benefits, area-based management tools, including marine protected areas, environmental impact assessment, and capacity building and transfer of technology. So those are the 4 areas. I'm not going to talk about MGRs, marine genetic resources, today, and I will touch on the others in the context of climate change. Now, the most recent consolidated draft was released in November 2019. It's available on the BBNJ website, which I've put up on the slide. And if you've looked at the draft, you'll see that an enormous amount of the treaty, most of the treaty, is currently in square brackets. So there is a significant level of disagreement on pretty much almost every issue at this stage. So I'm sort of working on the basis of that draft at the moment, but I have a caveat at the end of my presentation in connection with essentially the uncertainty that is in relation to the draft at the moment. It is, though, I think, really important to acknowledge that this is probably one of the most significant international law of the sea developments within the last 30 years. So it is quite an exciting kind of time for law of the sea and biodiversity scholars. So thinking about the question, well, will it contribute to kind of the ocean climate regime complex? Will it build a bridge between these regimes? Will it allow us to address climate change in the ocean? So thinking about sort of that broader question, I sort of have broken it down into sort of 6 narrower questions, or 6 criteria, kind of depending on which way you look at it. And I'm going to briefly look at each of those. So I guess my questions would sort of be, well, is it actually going to provide for specific obligations to mitigate the causes of climate change and ocean acidification? Is it actually going to regulate activities which directly relate to climate? And I'm thinking here particularly of geoengineering. Does it expressly refer to climate change and ocean acidification as issues which need to be considered as part of decision-making processes, whether that relates to area-based protection, environmental impact assessment, capacity building, etc.? Does it indirectly incorporate climate and ocean acidification as part of ecosystem approach, resilience approaches? Does it provide for science-based decision-making and actually appropriately support those processes through facilitating scientific research, bearing in mind that we don't know a huge amount about the deep oceans at this stage? And institutionally, more prosaically, but really importantly, does it provide for mechanisms and processes that allow for dynamic decision-making, for adaptive management, for review, bearing in mind that this is a complex dynamic environment and climate change really exacerbates that. So I'm going to look sort of briefly at each of those points through a couple of parts of the draft agreement. So just to say, this is the draft agreement. So this is the November 2019 draft that I am looking at here. So not in any way a final instrument, but the draft agreement. So taking that first question, I think it's not surprising that there are no obligations, and nor is it intended that there be specific obligations that actually seek to mitigate and provide for specific targets in respect of climate change and ocean acidification. So as a whole, the BBNJ agreement is designed to support and work in conjunction with existing sectoral and regional agreements. And in fact, one of the major complex issues which negotiators are having to grapple with is how this instrument actually supports, works with, interacts with these other instruments. And in some ways, the climate change regime is simpler than the others because one can simply avoid quite a lot of the specific obligations under the climate change regime. They can simply not be addressed in relation to the BBNJ. So there's never really been any significant discussion about actually having substantive obligations within the BBNJ agreement relating to climate change and ocean acidification. And this is notwithstanding that I think it is arguable, and certainly I have argued, that simply meeting climate change obligations under the UNFCCC is not necessarily going to meet your obligations to prevent pollution under UNCLOS, applying a due diligence approach. And I've looked at this specifically in the context of ocean acidification, but I think it's equally applicable in climate change. So I think that's a problem, but it's not a problem that the BBNJ agreement is going to address. Similarly, there doesn't seem to be any particular appetite to use this agreement to actually regulate activities which are directly related to climate change, particularly mitigating climate change in the oceans. And again, I'm thinking here of geoengineering. So currently, we have a partial regime relating to marine geoengineering. So the protocol to the London Dumping Convention addresses ocean acidification for scientific purposes. It also provides something of a mandate to extend to apply to other geoengineering processes where that involves putting something in the marine environment. But we certainly don't have a broader mandate to regulate marine geoengineering. But again, this is not something that the BBNJ agreement is going to directly regulate, although its provisions relating to things like environmental impact assessment, area-based protection may, of course, indirectly have implications for geoengineering activities beyond national jurisdiction. More positively, if we're looking at whether the draft BBNJ agreement expressly refers to climate change and ocean acidification, the answer is yes. Not very much in the context of quite a long agreement, but there are 4 express references to climate change and ocean acidification, which is reasonably positive. So the first reference is in Article 1, and Article 1 sets out the definitions of the various terms for the agreement, and cumulative impacts is one of those terms which is defined, and cumulative impacts is defined as the same as impacts on the same ecosystems resulting from different activities, including past, present, or reasonably foreseeable activities, or from the repetition of similar activities over time. And this is the important bit, including climate change, ocean acidification, and related impacts. You will note the whole provision is in square brackets at this stage. The second reference is in Article 5, and Article 5 sets out general principles and or approaches to implementing the BBNJ agreement. And one of the approaches it identifies is building ecosystem resilience, and ecosystem resilience is outlined in relation to the adverse effects of climate change and ocean acidification. The third reference is in connection with Part 3 of the agreement and area-based management tools. Article 14 sets out the objectives of Part 3 of area-based management tools, which include marine protected areas. And paragraph E, which includes the objectives, includes one, rehabilitate and restore biodiversity and ecosystems, including with a view to enhancing their productivity and health, and building resilience to stresses, including those related to climate change, ocean acidification, and marine pollution. And then finally in Annex 1, the whole of which is in square brackets, so it's not clear there will be an Annex 1, sets out indicative criteria for the identification of areas which can be subject to management measures, and that includes vulnerability as one criteria, and importantly, that includes vulnerability to climate change and ocean acidification. So certainly we have a number of express references, which, as I shall come on to, supports the implementation of a number of the provisions under the agreement to address, or at least to incorporate, climate change and ocean acidification issues within decision making. So I think we can say the strongest, and I'm using strongest in a relative sense as opposed to an absolute sense, because it's not very strong at all, but in relation to the rest of the agreement, the strongest reference to climate change and ocean acidification is in Part 3 in relation to area-based management tools, given that climate change and ocean acidification are identified as objectives as part of the Article 14 and indeed a criteria in Annex 1. Just for information, the definition of both area-based management tool and marine protected area are pretty standard. There's nothing really particularly exciting about that. So basically, a geographically defined area through which one or several sectors or activities are managed with the aim of achieving particular conservation or sustainable use objectives. That's in relation to area-based management tool, and a similar definition with respect to marine protected area. So positively, I think we can say, in terms of thinking about part 3 in the context of climate change and ocean acidification, what part 3 would do is provide a clear legal basis for the establishment of area-based conservation measures in order to enhance resilience in the context of climate change and ocean acidification in areas beyond national jurisdiction. Now, given the broader debates we've had really over the last couple of decades over whether you can have area-based protection in beyond national jurisdiction and what the legal basis that would be, that obviously is a very positive step forward. Moreover, the agreement endorses area-based protection on the basis of best available scientific information, relevant traditional knowledge of Indigenous peoples and local communities, a precautionary approach and an ecosystem approach. So there are a number of different factors which arguably would support appropriate area-based management. So the scientific information, traditional knowledge, a precautionary approach and an ecosystem approach. And it also appears to provide for a level of consultation and collaboration. And finally, the agreement provides for monitoring and periodic review by a proposed scientific and technical body, and a process whereby the conference of the parties may decide to extend, amend or revoke area-based management tool on the basis of an adaptive management approach. So there's an element of dynamic management which is being incorporated potentially into the treaty. Now, I think it's worth noting that the process of how area-based management measures will be adopted has yet to be decided. So there is actually a disagreement at the moment on whether it will be at the international level through an institution of the BBNJ agreement, whether they will have a mandate to establish MPAs and other measures generally, or probably more likely in areas where there is no other institution with such a mandate, or indeed whether the BBNJ agreement will rely on existing institutions, so RFMOs, regional seas, the IMO, for example, to designate protected areas, with its role being confined more to a coordinating or advisory body. So that potentially will have quite a significant impact in terms of the effectiveness of implementing these provisions with respect to climate change and ocean acidification. So that's a significant question which is up in the air. However, even if we put that level of uncertainty aside, I think we can be quite critical of part 3 with respect to climate change and ocean acidification. In fact, I've put in my notes here, I've described it as wholly inadequate, but I'm now wondering whether that perhaps goes a little bit too far, but certainly critical. So what is sort of the critique that I would identify? Well, I think first off, notwithstanding the endorsement of an ecosystem approach under Article 5, and indeed under Part 3, at the moment, it's currently unclear whether fisheries are going to be excluded from the mandate or the general mandate of the BBNJ agreement. So I think it's accepted that fisheries will not be included in respect of the part which refers to MGRs, marine genetic resources. But at this stage, it's not clear whether they'll be fully excluded from the mandate of the BBNJ agreement, but there's actually significant state support for excluding fisheries from that mandate. So really, from the perspective of managing climate change, ocean acidification in areas beyond national jurisdiction, if we exclude fisheries from the management approach, that is quite a significant lacuna, quite a significant activity to exclude from that approach. And that I think will have significant impact in terms of any potential effectiveness with respect to biodiversity. So that's the first issue. The second issue is that it actually takes, the draft agreement takes quite a narrow approach to thinking about area-based protection, in that the focus is very much on vulnerability and on areas which are currently impacted by the negative impacts of climate change and ocean acidification. There's no reference to what is sometimes described as climate refugia in the objectives in Part 3, or indeed in the criteria in Annex 1. So climate refugia really refer to areas which are not currently impacted by climate change, and which actually are quite resilient and are believed to be quite resilient to climate change, and therefore are deserving of protection, given kind of what else is going on in the ocean. So there's quite a lot of discussion. Actually, we should now be identifying those resilient areas and actually protecting those resilient areas in addition to those which are vulnerable. And there doesn't seem to be a basis to do that, still less a requirement under the draft BBNJ agreement. And then the third criticism is that the draft agreement does not really adequately address the inherent tension between the static nature of an area-based measure and the highly dynamic nature of the ocean environment, which is exacerbated by climate change and ocean acidification. So it does provide for a process of review. There's a reference to adaptive management. But I would suggest that those provisions are pretty inadequate in the context of actually what we need in terms of dynamic management. In this context, I think it's worth noting a recent assessment of area-based management tools in the North Atlantic by David Johnson, Maria Ferreira and Ella Kenshington, which was published in Marine Policy in 2018. And they were highly critical of what in actual fact is a very well developed network of area-based protection developed in the region. But even though this was actually a very well worked out network, they found that the majority of the measures are likely to become redundant in the next 15 to 20 years as a consequence of changing climate. More generally, in a multi-authored article published in Marine Policy in 2020, the authors make a strong argument for adopting temporal scales of management in addition to spatial scales of management. And they advocate for what they describe as dynamic ocean management. They define this in slightly unwieldy terms as a management approach that uses spatio-temporal resolution, environmental and biological data to enable rapid and optimal management responses to change and distribution of biological resources. So not the most accessible of definitions and not something I would advocate being included into the BBNJ agreement, but the essential point is that management needs to be spatially, temporally and biologically adaptive, and I don't think the provisions within the agreement provide for that. So the basic definitions of area-based protection are pretty standard, pretty simplistic. The second area where the BBNJ agreement can potentially contribute towards measures relating to climate change and ocean acidification is in relation to environmental impact assessment and strategic environmental assessment, and these are set out in Part 4 of the agreement. Now, as is the case for area-based protection, much of this part remains in square brackets, and there are significant differences between a number of alternatives with respect to the extent of the obligation, the threshold at which NEIA is required, the relationship between the BBNJ agreement and between various other regional and international instruments. Now, in contrast to Part 3, there's no explicit reference in Part 4 to climate change and ocean acidification, but there are several references to the need to consider the cumulative impacts of activities And in fact, Article 25, draft Article 25, is devoted to cumulative impacts. And of course, as I said earlier, cumulative impacts is defined to include reference to climate change and ocean acidification, at least in the current draft. So this makes it clear that states are required to consider climate change and ocean acidification in their decision-making processes associated with environmental impact assessment. What's not clear at this stage is whether the EIA processes will apply only to activities taking place within ABNJ, or whether the agreement will apply to all activities which have an impact on ABNJ. The latter articulation obviously is much broader and will potentially capture activities under the jurisdiction of states, but which nevertheless impact ABNJ. And of course, in relation to climate change and ocean acidification, the causes of those are largely land-based as opposed to sea-based. One issue which has yet to be decided is whether the agreement will provide for a list of activities that require an environmental impact assessment. And I guess there is the potential under this for things like geoengineering potentially to be listed. So there's a sort of a possible advantage with that approach. But as I say, that has yet to be decided. Other provisions of interest through the climate lens are Articles 27 and 28. Article 27 provides for a mandatory EIA in respect of activities taking place in vulnerable areas, or in respect of those areas, additional criteria would apply. So that potentially would strengthen these processes in the context of climate change. Note the whole provision is in brackets there. And Article 28 is strategic environmental assessment. So this is those broader assessment processes that apply to programs and plans. And again, the question I think there is, are we simply talking about activities carried out beyond national jurisdiction, or do they apply to a much broader range of activities which impact areas beyond national jurisdiction, in which case you could be looking at activities such as shipping, for example, in terms of strategic environmental assessment. More generally, it's worth noting kind of Article 5, which sets out those general principles and approaches. We've already noted paragraph H there in terms of ocean resilience and the reference to ocean acidification and climate change in the context of resilience. But actually other principles such as precaution, the ecosystem approach, integrated approaches are all supportive of integrating climate change and ocean acidification into decision-making processes. Very briefly, the fourth component, or the third component I'm looking at today, but the fourth component overall, is capacity building and transfer of marine technology. Probably been a bit neglected, I think, in terms of the negotiations so far. Understandably or predictably, there are significant disagreement as to how far those obligations would go, whether we're talking about financial, knowledge, technology, etc. But even acknowledging those disagreements, whilst there's no doubt that the broad objectives under Article 42 are broad enough to include technology and knowledge associated with climate change and ocean acidification, there's no specific reference there to them. So there's no express reference that states should share their knowledge and technology with respect to climate change. One could argue, well, that's not surprising. Of course, under the climate change regime, there's a whole set of provisions which relate to technology transfer and support. But I think, again, there are potential opportunities to build on that and to support that in the context of the marine environment, but there doesn't seem to be any particular interest in doing so. And then finally, I think it's fundamental, if we're going to try to address climate change and ocean acidification, that we actually need sufficiently dynamic and resilient institutional infrastructure. So one of the challenges with the Law of the Sea, particularly the Law of the Sea Convention, is that we don't have those institutions to actually develop the institution or develop the regime as such. So we're very much dependent upon other institutions, on United Nations General Assembly. So that makes it really challenging. So certainly the draft agreement as it stands is looking to establish quite a number of institutions, including a COP, a scientific body, potentially a secretariat, a financial mechanism. So there is sort of scope there to provide for a level of dynamic management. There's obviously a very significant level of disagreement as to kind of the scope or the mandate of these institutions. And I think one question which I have is how decisions will be taken. And it does look as though they will adopt a consensus model. And I think that's obviously potentially quite challenging. We've seen that elsewhere in terms of actually taking decisions. So kind of returning to my kind of questions, so will it support efforts, will the BBNJ agreement support efforts to address the impact of climate change? At the moment, I suppose I've got a qualified yes, and if I'm feeling kind of optimistic and positive, then we'll go for a distinct yes. So climate change and ocean acidification are both expressly identified as factors related to ocean's resilience. So that is a positive, that's a really big tick. And as such, they do need to be considered as part of EIA processes. And of course, that assumes that the current definition of cumulative impacts remains within the draft. It is yet to be agreed as to whether those processes, the EIA processes in particular, will apply to activities within a state's jurisdiction that impact upon biodiversity on national jurisdiction. And this is an option. And of course, this would be a much preferable option in terms of addressing climate change and ocean acidification. This process, I think, together with kind of a strategic environmental assessment, does provide potential to require states to consider their economic and industrial programs more generally in the context of the impact of those programs on the oceans. Climate change and ocean acidification are also expressly identified as factors that contribute to ecosystem vulnerability, therefore justifying area-based management mechanisms. However, as I've indicated, I think probably part 3 as it stands is pretty inadequate in terms of the potential responsiveness to those threats. So the definitions of area-based management and indeed marine protected areas focus really only on spatial protection. They don't include a temporal dimension at the moment. And although there are provisions for review and revision, it's not clear that those are sufficiently dynamic really to address the very particular challenges posed by those two risks. And I think to an extent this represents a bit of a lost opportunity, given that there is a significant level of research and which would sort of advocate for a much more dynamic approach. So it's a bit of a shame that we seem to be harking back to those traditional mechanisms. And as I mentioned, I think it's defined quite narrowly, and the lack of kind of protecting resilient environments, creating climate refuge is also a bit of a lost opportunity. If we do exclude fisheries from the BBNJ agreement, which I suspect we will, that I think will be a significant problem in the sense of really undermining holistic ecosystem management and essentially being able to build resilience in the face of climate change. And while climate change and ocean acidification are expressly identified as cumulative impacts and as factors which contribute towards ecosystem vulnerability, neither threat is front and center of the agreement. So the agreement certainly doesn't and won't appear to contribute towards obligations to mitigate climate, carbon dioxide, other causes of climate change, doesn't address ocean acidification, and certainly doesn't appear to be a forum from which to regulate geoengineering more generally. So I would suggest that there is the potential for the BBNJ agreement to be kind of part of the oceans climate regime complex and potentially quite an important part, but not really as a fundamental kind of bridge between the regimes. And I would also just like to end, and I don't really like to end on a negative note, but I am going to end on a little bit of a negative note, is that this analysis is on the basis of that revised draft issued in November 2019. And a significant number of those provisions that I've looked at are in square brackets. So there is the very real potential for quite a lot of those provisions actually to be watered down, or indeed to be removed altogether. And if you have a look at the suggestions made by states, and again, these are all nicely made available on the website, and I admit I've only made a cursory look. This is something I'm going to go into in a bit more detail. Quite a large number of the submissions actually involve kind of watering down and removing a lot of these provisions, particularly in relation to climate change. And I've just put two examples here with respect to the definition section on cumulative impacts, and actually either removing cumulative impacts from the definitions altogether, as advocated by Korea, or removing the reference to climate change and ocean acidification and cumulative impacts as suggested by the European Union. So I think there is actually quite a significant risk in that what I would consider to be a reasonably positive, not fully positive, but reasonably positive assessment could actually turn out to be significantly less positive if those provisions are watered down. So it'll be really interesting to see what happens in August 2021, assuming negotiations are able to resume. So I appreciate I have gone somewhat over my time, Hannah, so my apologies for that, but thank you very much. Oh, that slide's meant to say thank you and it doesn't. So thank you.
Thank you so much, Karen. Fantastic. And I was not going to interrupt that at all, because I think we're all here to hear from you. So no cutting you off, and we've still got plenty of time. 15 minutes for questions. I have a couple, but I'd like to open it up to the floor first. So anyone who has questions or something they'd like to ask Karen, please either raise your hand and then I will unmute you and you can go for it. Let's start with Michelle, and also happy to have comments or questions in the chat, which I can get to as well. Okay, fire away, Michelle.
Thanks, Hannah, and thanks, Karen. It's actually two comments that I have. The first is that I think you've really demonstrated why Hannah opened with that introduction of the amazing Karen Scott, of linking together three very interesting regimes. And my second comment, which I feel might end up in a bit of a rant, is how ridiculous it is that fisheries is not included as part of BBNJ, because it's the #1 driver of biodiversity loss in the oceans, but also, again, a further point linking to this nexus is, I was just listening to a presentation the other day about there's some types of fish that have this capacity to sequester carbon, like deep sea dwelling fish, which can sequester carbon in a really quick way, because somehow, and I don't know the technicalities of it, but then they draw, because they live on the surface sometimes, and they can then draw carbon into the deep sea. So just a comment about how short-sighted it is that fisheries hasn't been included.
I couldn't agree more. And I think this isn't so much a climate issue, it's a broader issue in terms of sort of really delineating between the various mandates of the large number of institutions which have a responsibility for regulating activities. And as in really any context, whether we're dealing with international, national, or indeed universities, there is an incentive to protect one's turf and to resist the intervention of others, and that is essentially where that is coming from. So it's sort of preserving the mandate of RFMOs, and it'll be really interesting to see how that operates out. There is, I mean, I think there is real sort of scope for sort of area-based protection, even if fisheries are excluded. Area-based protection, I think, does represent, a potential opportunity to try to support indirectly those sorts of activities in relation to managing sort of other activities. But of course, as you absolutely rightly say, particularly in relation to the deep ocean, fisheries is, the really significant, threat. And that's so fascinating. I did not know about the sort of the specific. I know that the sort of biological cycle sort of, yes, involves fish sort of taking in carbon dioxide and then, if you'll excuse me, sort of, I think, pooping it out, and it goes under the seabed. But it sounds as though there's a more sort of active measure, and I think, and that really demonstrates, I think, that we just don't know so much about ocean processes and so much about the deep ocean. And if we're attempting to devise a regulatory regime in the absence of relevant knowledge, that's problematic. But thank you, Michelle.
Yeah, thanks so much, Michelle, and thank you, Karen, for that response. We have another question from Otto. I'll just unmute. Hi, Otto.
Yeah, hello, thanks. My question is of a more general nature. Oh, by the way, I'm a professor of international law at Wuhan, so that's in China. So my question is of a more general nature. I was wondering, so what if we do reach an agreement and there is a convention adopted, but then nobody wants to ratify it? So can it then still sort of be used as a evidence of an emerging state practice or opinio juris, so as a basis for customary norms? I mean, I'm thinking of the UN Watercourses Convention as an example that's also been ratified by very few states, but it's still quite influential in the development of customary law. So that could maybe be like a way to ensure its significance.
Thank you, Otto. I think that's a really good question and point, and you're absolutely right. We've got the challenge of actually getting to the point of adopting an instrument, but even if you get to that point, things are not necessarily rosy at that point. It has to be ratified to enter into force, and of course we have numerous examples of where that may well be challenging. I think there certainly are examples, and there, once you have got something there is the potential for states to pick it up, to use it, and for it to be incorporated into customary international law. And of course, I think the Law of the Sea Convention itself, provides the example of that. So it largely binds the United States, for example, other than Part 11. The United States is not a party to it. I guess the challenge is distinguishing between states which are quite happy with the agreement, happy to apply it, but for whatever reason haven't ratified it, with those which actually reject it, which object to those provisions. So it will be interesting to see how states do react to it. And of course, it's there's the real potential there for states to be reasonably happy with, say, parts of the agreement, particularly relating to sort of area-based protection, for example, but to object strongly to marine genetic resources, and therefore not to ratify it, because it is a package deal. And of course, again, we saw that in relation to UNCLOS. So I think your point about we are at the very early stages of this is really well made, but also not to necessarily get entirely hung up on the idea of entry into force, and there may well be other ways that we can utilize this. Yeah, so thank you very much for your remarks, and thanks for joining us all the way from Wuhan.
Thanks, Karen, and thanks, Otto. Yeah, it's fantastic. The one benefit of this kind of Zoom approach is that we can talk to people from all around the world, although I recognize some of us might be in very unfortunate time zones for this event, so I appreciate everyone taking the time. Karen, I have a question here from Roberta that came to me in chat. Actually, two questions, and the first one ties in nicely to what we've just been talking about around kind of the role of states in ratifying and ultimately implementing and enforcing this type of law. The question says, how do you expect the change in administration in the United States to impact IGC4 with respect to climate change? So maybe start there, and then I'll introduce this second question, which might be quite a nice kind of closing or bringing us to a kind of close.
Well, thank you very much. Well, I think in terms of climate change, I would suggest the change in administration is positive. I mean, I don't think you can see it as anything other than positive. And I do caveat my remark in relation to climate change, because I'm not sure that necessarily follows through with respect to all other parts of the agreement. I mean, certainly even over the last couple of weeks, President Biden has obviously taken a strong leadership role in terms of announcing very significant emissions reductions, and I certainly see that as very, very positive. I would hope that that would carry through in relation to the climate change provisions within the agreement. I have only had a very cursory look actually at the US's comments in relation to some parts of it, so it's not comprehensive, but actually there did not seem to be objection to the references to climate change and ocean acidification in those provisions, in contrast to the EU, which appeared to object to those references in relation to cumulative impacts. Whether there is a broader change with respect to the BBNJ agreement more generally, I mean, I think the US has sort of been cautiously supportive, but obviously has very particular views, particularly in relation to MGRs. So we shall see. But I think, I would hope it would be positive. I can't see it would be anything other than positive. That's not necessarily mean that it's perfect, but I don't think we could have been in a much worse position over the last 4 years. So I think, yeah, positive, I would say.
Fantastic, thank you. And always nice to have a kind of positive note to discuss when we're often quite critical of these things. Just before I tie up with Roberta's second question, I might just add something in there, which is you've spoken a lot about some of the kind of missed opportunities or limitations in BBNJ, and one of those being around this kind of failure to recognise refugia and this lack of recognition of temporal as well as spatial dimensions and the climate change relationship there. I wondered what you thought the kind of reasons for the absence or missed opportunities were, whether they are technical or whether they're political, and what your view was on that.
I think that's a really good question, Hannah. And I think, to be fair to the negotiators, it is really hard to be devising processes in relation to sort of untested issues, and particularly at the global level, where inevitably you tend to be heading towards the lowest common denominator. So I think in some ways it's a shame that we don't have more examples at the regional level of organisations attempting some of the sort of innovative ways of particularly developing MPAs, and indeed at the national level. So I think a lot of the research, which is advocating particularly, for a temporal approach, which seems eminently sensible from a scientific point of view, is very hard to try to implement in practice. You need appropriate institutions, you need review, you need the expertise, you need the scientific information to sort of predict as to what you need to protect at various different points of time. And we actually don't have that often at the national level, let alone at the international level. So I think whilst it's critical and it's a lost opportunity, I think it is understandable. And I suppose I would advocate for genuine processes which allow for reasonable review and amendment, so that as we become more confident in some of these processes, we can actually amend and change what is in the agreement. But it is more difficult, I think, to do this at the global level as it is, perhaps at a regional level, where you have a more cohesive group of like-minded states. You have fewer kind of ecological conditions to deal with because you're just covering a smaller area. So yes, I think I'm critical, but I can also, I can actually understand, why the states haven't kind of pushed forward as much as perhaps we would like.
Thanks, Karen. And that ties in quite nicely to the second question from Roberta, which is, if you had a magic wand, which would always be nice, what would be the one thing you would change in the BBNJ agreement with respect to climate change that is currently not there?
That's a fantastic question. So just one thing, I would make it clear that the mandate would cover fisheries, I think, would be my one thing. There are quite a lot of things I would like to do, but I think ultimately, if I had to limit it to one, I think if we exclude fisheries thoroughly from the agreement, then its effectiveness is really going to be quite limited. So that would be my one thing if I had my magic wand. And I may get my wish. It has not been decided officially that fisheries will be excluded. So, you know, it may happen. But yeah, it depends how positive I'm feeling as to as to whether I think that will likely happen.
How magic the wand is.
Yes.
Thank you, Roberta, for those questions. Do we have any? I think we have time for one more question before we close. We've got 3 minutes left. Does anyone else want to throw something in? And Roberta says, thank you very much, Karen, for those responses.
Yes, I think I will just throw one last question to you, Karen. And when they are discussing the exclusion of fisheries, how would that be possible when they are discussing the area-based management approach? I mean, I just don't get it. I mean, area-based management approach is about fisheries. It's not all about fisheries, but it's about fisheries. And also, is this a sign that that debate on not undermining principle? I mean, it's huge debate around that not undermining principle basically have a conclusion that not undermining means what? Means not touch the existing.
Yeah. Yeah, no, two you know, really good components to that question there. In relation to sort of the first part, it would certainly limit it. I mean, I think you'd probably be you know, you're restricted to managing other activities, and of course that is an important component of area-based management. So if you limit sort of mining, other activities, then you're at least lessening some of the pressures with respect to ecosystems. But it certainly would be challenging. So I think in terms of what we mean by is that there would be no sort of directed regulation of fishing or scientific fishing, you know, catch limits, anything of that nature. And I guess you can understand you know, the role of the RFMOs and how that would work. So I think, you know, and if you weren't able to sort of properly coordinate, so I think if you know, not all is lost if we exclude fishing, but it really would require, you know, really tight coordination and quite a lot of goodwill on the part of RFMOs to try to cooperate and actually manage their fisheries in order to support MPA processes. And in relation to not undermining, I mean, you're absolutely right, and I think there isn't sort of full agreement. So you could say, yes, not undermining means, as you describe it, kind of no touch. So you just don't get involved in relation to an activity which is managed by another institution. I would not support that approach. Some states do. I would suggest a much better approach is that you don't take measures which are likely to undermine or impair or make more difficult the mandate of that institution. So if you are taking measures which support that, which go beyond or support, then I would say that that's not undermining. But there is that certainly isn't that isn't a universal view. But I would suggest it's a better view.
Thank you very much. Thank you for this fascinating presentation.
Thanks, Ning, and thank you, Karen. Okay, very sad to say that I think we are over time, out of time, but thank you so much, Professor Scott, for speaking to everyone. Thank you for the great questions. Really appreciate everyone's time. Thank you, Karen.
It's an absolute pleasure. Thank you very much for including me in the series and for all the excellent questions.
Fantastic. Thanks, everyone. Have a great day, and make sure you check out Karen's work. And also future Law and Nature dialogues as we continue throughout the year. Thanks again.